Lawyers, what was the dumbest thing that won or lost you a case? Story 1. I had a fairly simple assault trial. Facts are a pretty basic. Homeless guy was told to leave by security and was ushered away. Homeless guy got upset and hit the security guard. We have some cell phone footage that shows this, but ultimately the key moment wasn't clear, and it could have been argued that the security guard touched him first. Defense counsel asks the defendant a few questions, then goes in front of the jury and asks him to essentially position her how the security guard was and reenact what happened. They more or less agree that she should be standing about arm's length away and pointing. You know, like a typical, hey, you can go exist there, but this is private property kind of thing. She then asks, and what did you do? My dude looks right at her and slugs her right in the mouth. Not even a gentle reenactment tap, but fully committed to trying to knock her out. Her lip is bleeding, and she looks shocked, like she was fully unprepared for it before sitting down. Skeleton, any cross? Just briefly. Sir, just to confirm, you hit the security guard just like that? Yes. Up until that time, did the security guard ever touch you? No. No further, Judge. I didn't even get out of the courthouse parking lot before I got called back for the verdict. Answer. I was on jury duty a few years ago. One of the cases was a domestic abuse thing, which overall wasn't very nice to sit in. The dumb moment was the accused was being asked if he had sent threatening messages to his former partner's new boyfriend. He said no, and the defense went with, well, the number on the phone is unknown, so it could literally be anybody, couldn't it? Well, the new boyfriend says, actually, I know it was him. Defense scoffs at that idea. And how did you know it was him? New boyfriend says, well, it was via WhatsApp, where you can click onto the number and it'll show you the profile of who it is, even if you don't have their number. When I did that, it showed defendant's name. Defense was like, wait, what? With the judge checking in, do you still have the messages so you can show me this? Defense, wait, no. New boyfriend, yep, here you go. It all happened in the space of like 5 minutes and was hilarious. The defendant didn't seem that fussed, but his defense lawyer was like, we're so fudge. Said fellow was later charged for various things, including beating his former partner, and was sent to jail. Story 2. Public defender in first felony trial, meth trafficking, where they had the whole exchange caught on video, including my client's alleged haha face and his license plate as the exchange took place in his car. When arrested the next day, he still had the marked bills in his wallet. All I could argue was reasonable doubt probably is enough. He was facing 20 years because of his record. After 10 minutes out, the jury came back and asked if they could see my client's teeth. On the video, he had a bad case of meth mouth, but he had not testified, so the jury didn't get a chance to look in his mouth in person. The judge said sorry, the proof was closed. They came back not guilty 5 minutes later. Spoke to foreman after. He said they were pretty certain it was him, but his teeth were so distinctive they wanted to see them to be absolutely certain. I asked, what about the license plate and marked bills? His brow furrowed. That actually didn't come up back there, but yeah, I guess it was definitely him. Should we tell the judge? It's too late. It's over. Answer. Kind of similar. Friend was on a jury for a case where a guy got arrested for allegedly selling substances at a park. Guy's defense was no. He was there to play basketball, and the cops planted the substances. A few other in the jury wanted to vote not guilty based on that being possible. My friend had to remind them that it was nighttime and dark. No lights in the park. Guy was by himself and was not in the possession of a basketball. Story 3. Not my story, but one I heard as a young lawyer, illustrating the dangers of asking too many questions on cross-examination. The lesson being to quit while ahead. Don't ask open-ended questions that allow the witness a chance to explain. The case was about a vicious fight outside a bar. The accused was accused of biting the victim's nose off. The only witness was an elderly fellow who saw the whole thing. On direct, the witness said he saw the two fighting in a whole crowd of brawlers from across the street at night. The defense cross went something like this. Q. I see you are wearing glasses here in court. Are you nearsighted? A. Yes. Q. From the police report, it says you were not wearing your glasses that night. A. Yes, I ran out of my house without them when I heard the riot. Q. Again. From the police report, it was particularly dark and foggy that night. There was only a single light above the bar, and you were 100 feet away. Is that correct? A. Yes. Q. So, you admit you are nearsighted, that the visibility conditions were not good. You could not possibly have been able to see exactly what happened 100 feet away from you, correct? A. Well, yes, but Q. Please just answer the question A. Yes. And here the lawyer ought to have sat down. Instead, they opened their mouth and asked the fatal question. Q. So given you admit you could not have seen exactly what happened, why did you testify it was my client who bit off the victim's nose? It could have been any one of those fighting A, because later your client ran right past me and spat a severed nose onto my shoe. The latter bit had not been in the police report and was not mentioned on direct. Answer, Vinnie Gambini. Mrs. Riley, when you saw the defendants, were you wearing your glasses? Constance Riley. Yes, I was, Vinnie Gambini, pointing upward and Mrs. Riley not looking in his direction. Over here, dear, would you mind putting your glasses on for us, please? Vinnie Gambini, stumbling a bit from staring into Mrs. Riley's eyes through her very thick glasses. Whoa, how long you been wearing glasses? Constance Riley. Since I was 6, Vinnie Gambini. Have they always been that thick? Constance Riley. Oh no, they've gotten thicker over the years. Vinnie Gambini. So, as your eyes have gotten more and more out of whack, as you've gotten older, how many different levels of thickness have you gone through? Constance Riley. Oh, I don't know, over 60 years, maybe 10 times. Vinnie Gambini. Maybe you're ready for a thicker set. Constance Riley. Oh no, I think they're okay. Vinnie Gambini. Maybe we should make sure. Let's check it out. Vinnie Gambini. Grabbing a tape measure from his desk and bringing it over to Mrs. Riley. Now, how far away were the defendants from you when you saw them enter in the sack of suds? Constance Riley. About 100 feet. Vinnie Gambini. 100 feet. Vinnie Gambini. Handing Mrs. Riley the end of the tape measure. Would you mind holding this, please? Thank you. Vinnie Gambini, making his way through the crowd to the courtroom door. Sorry, excuse me, sorry. Okay, this is 50 feet. That's half the distance. Vinnie holds up 2 fingers on his right hand. Vinnie Gambini. How many fingers am I holding up? Mrs. Riley is squinting, trying to see the fingers. Judge Chamberlain Haller. Let the record know that the counselor is holding up 2 fingers. Vinnie Gambini. Annoyed. Your Honor, please, huh? Judge Chamberlain. Haller. Oh, sorry. Vinnie Gambini. Now, Mrs. Riley and only Mrs. Riley. Judge Chamberlain gives Vinnie a dirty look. Vinnie holds up 2 fingers on his right hand again. Vinnie Gambini. How many fingers am I holding up now? Constance Riley, squinting, trying to see the fingers. 4. Vinnie Gambini. Coming back to Mrs. Riley amid the courtroom rumbling in, she getting the number wrong. What do you think now, dear? Constance Riley. Thinking of getting thicker glasses. Story 4. Not a lawyer, but I do technical work for lawyers. I'm going to generalize this excessively because it's a real case. Did some data recovery analysis of a dash cam from a company vehicle involved in a very serious accident. Driver claimed to not be at fault. After doing recovery on the SD card from the camera, I found a video of a company manager sitting at the wheel in the company garage, weeks after the accident, while the vehicle was supposed to be quarantined as evidence. He was on the phone with someone receiving instructions to do stuff to the dash cam. We could hear him say, "No, I already pushed it." He had pushed the red record incident manually button and recorded himself tampering with evidence, presented in pretrial negotiations. Case settled immediately in favor of my client. Answer: this wasn't a court case, but sort of similar. At a company I used to work at, I was part of our incident review team. Anytime there was any sort of accident with any of our company vehicles, we reviewed the drive cam footage. One of our technicians had hit a low-hanging tree branch. No one was hurt, but it did significant damage to the service van. He swore the branch must have fallen as he was driving by because he never saw it until he heard it hitting the van. We sit down to watch the video. He is texting, eating a hot dog, and looks straight ahead and yells, "Oh shoot, a tree." I'm not sure why he felt the need to lie. It was near impossible to get fired at this company. He wasn't fired for this, just written up and had to take a safe driving class. Story 5. This wasn't a trial, nor am I a lawyer. But at one point, I was interning for a family law attorney. He had this one divorce case he was in the middle of, and I sat in on client meetings and mediation with the other party. They were discussing custody and weren't able to come to an agreement, so I proposed a potential agreement to our client, and after the other attorney talks it over with their client, they accept. After we leave the client, I'm riding high on the thrill of resolving things, when the lawyer I was interning with told me that the custody schedule I proposed was identical to one that had come up earlier in negotiation. The only reason they accepted this time is because both parties perceived me as a sort of neutral third party, so they believed the compromise was more fair than when it had been proposed by one of them. Answer: after we leave the client, I'm riding high on the thrill of resolving things, when the lawyer I was interning with told me that the custody schedule I proposed was identical to one that had come up earlier in negotiation. If it helps, you did. Just not because of the schedule, but the way in which you were able to present it to the client. Either way, you helped. Story 6. Nayel, but on jury duty, a father and son got into a physical argument. Both adults. Son pressed charges for simple assault. There was plenty of evidence to acquit as it sounded like mutual combat. Son was kind of a shithead and was egging him on, pushing, etc. up until the punch that busted his lip and lead to the cops being called. We were ready to acquit up until the dad took the stand. Virtually the first thing out of his mouth, "Oh yeah, I whooped his jerk good," with plenty of detail. His lawyer and judge both visibly shook their heads. Had to convict. Story 7. Do administrative proceedings count for this question? Years ago, I was working for a partner doing municipal and planning law matters. He had a client, a Hindu group, originally from South India but established here in Canada, who wanted to build a community center. They were being blocked by a municipality in the flimsiest grounds. The correspondence, back then, all on paper, it's that long ago, being unbelievably rude and dismissive of our client. Naturally, the client assumed the municipality planning office was full on racists. How else to explain their bizarre behavior? Mind you, and this is important, they had never actually met for an in-person meeting. This was all by correspondence. At the first meeting with the client, they were fighting mad. They wanted to launch a proceeding right away, had in fact already filed the paperwork before they realized they needed professional help, which would have earned our firm tens or even hundreds of thousands of dollars in fees. I was given the task of summarizing and categorizing the correspondence for the partner. In a single glance at the correspondence, Brad told me what the problem was and how to solve it right away, and sadly lose our firm those hundreds of thousands in fees. The group was called something like the Vedic Aryan Society. Their decorative letterhead had an ornamental border of swastikas. It was obvious from the correspondence that the city planners had literally no idea who Vedic Aryans were or that they were originally from South India. They were acting under the assumption these guys were neo-Nazis because of the use of the word Aryan in the decorative swastikas. Just as the clients assumed the planners were vicious racists, so too did the planners assume that the clients were vicious racists, hence turning down the application on flimsy grounds, the nasty tone in the correspondence, which virtually said, "We don't want your kind in our community," etc. A single letter carefully explaining this was basically all it took. The application was approved, the proceeding withdrawn, plus some free advice, which was that a different choice of decorative border would avoid such issues in the future, and hence the dumbest possible waste of time was avoided. Answer, I just read in another thread about people have problems naming babies. A lady was complaining that her husband, who is Indian, wants to name their kid Aryan, which is a Sanskrit word that means noble. She is trying to talk him out of it because they live and their kid will grow up in America, where that has very negative connotations to it. He has final say because they made a bet. If they have a girl, she gets to pick the name, no questions asked, and vice versa. He is refusing to budge. Story 8. I had a client charged with illegally camping on public land, aka being homeless in public. I moved for a dismissal at first appearance based on lack of probable cause. The municipal code defined camping as sleeping outdoors between 9 p.m. and 7 a.m. I pointed out that the police citation showed that they ticketed my client at 8:30 p.m. Story 9. I had a client when I was working in the clinic at law school. She had stolen pills from a hospital, and the DA sent me security camera footage. It was legit her like 10 firm out from a camera, looking around and shoveling pills in her pocket. I asked my professor how to approach it, and he suggests showing her the video. I did that, and her response was, "So, do you think I have a case?" She ended up magically finding money for a non-public defender and fired me. She ended up getting a few years in jail. Answer. When I was in APD, this always baffled me. People would come in with the most clear-cut evidence against them. The only thing you could do was negotiate a plea deal that was as favorable as possible to them. They would then hire a private attorney and spend hundreds of dollars for what I could get them for free. The worst was this one time. Guy comes in on a suspended license charge. Super minor and easy to deal with. I told the client this wasn't a case to fight because he can't win, and he goes out and hires a private attorney. The next time he shows up to court with said attorney, his new attorney literally asked me what the prosecutor wanted in terms of a plea, and I handed her the plea form I had filled out at the previous court appearance. She literally just has this dude sign the form I had already filled out, and they enter the plea. His private attorney probably did 15 minutes of work total on the case max. This dude could have saved himself a couple $100, but decided he didn't trust my opinion at the time. Things like that happened dozens of times. There were even a few times where my former client got a worse deal after getting a private attorney because they didn't trust a public defender. Story 10. My uncle went to watch my dad, a defense lawyer, in court on 2 occasions. Both times, my uncle was identified by a witness as the suspect. Dismissed and dismissed. Answer: twice I was the primary witness in minor criminal cases, and I was asked if I could ID the suspect in a crowded outer room hallway before we even entered the actual courtroom. Both times I was able to quickly do so. In both instances, I was told by the prosecuting attorney that if I had not been able to correctly ID the suspect in that pre-trial setting, they would not have proceeded. So not at all like the movies with a witness in the stand dramatically pointing to someone seated in the courtroom gallery. Story 11. NIL. I was told this story a long time ago. Local PD had been working undercover as homeless people and were targeting muggers in the city center. The defendant was in court with a cast on his leg and crutches nearby. He'd been shot by the arresting officer. The officer was on the stand giving the details of the arrest, and it went something like this. I was working undercover on the mugging task force dressed as a homeless person. The defendant produced a knife and demanded my wallet. I gave him the wallet and he fled on foot. I gave chase, identifying myself as a police officer and ordering him to halt. The defendant continued to flee, and after multiple warnings, I drew my revolver, took careful aim, and disabled him, which allowed me to effect the arrest. The defendant jumped up and yelled, "Your Honor, that policeman's a liar." After I took his wallet, all I heard was, "Guess who?" Bang! No idea what the outcome was. Story 12. Heard this one from a friend defending a client charged with beating a man to passing with a bat. Cops found him shortly after, a block away from the crime scene, holding a bat and wearing a coat, both covered in the victim's blood. He argued at trial that he was walking down the street minding his own business when another man offered him a free coat if he would hold his bat for a few minutes. He said he accepted the bat and put the coat on. He then proceeded to wait for the mysterious man to return when the cops found him. Jury was not out long before returning a guilty verdict. Story 13. This is more funny than anything. I'm a contract attorney in the entertainment and sports world. Had a client who's a mid-level writer-director calls me one day and says, "Hey, what legally constitutes a contract?" I explained the basics that there has to be an offer of terms, acceptance of terms, consideration of value, mutual agreement, capacity to make the agreement, and the offer in question has to be legal. I hear silence and then shit, we may have an issue. Goes on to explain that he was in Vegas for the week and got to talking to this guy. They are having fun, getting goofy, and the guy pitches him a story. He loves it, and long story short, he writes it on paper the bartender had. That on the date, he agrees. If he uses this idea, the guy either gets 25 profit or a part in the idea his choice. He signed it, the guy signed it, and the bartender witnessed it. I laugh. He says, "But I love the idea. I've legit spent the night writing it out. How fudge am I?" I ask him who took the signed paper. The guy did. Were you tipsy? Stone cold sober. Was the guy tipsy? He never saw him drink. I said risk factor is low but possible. He is a bit upset, asking if he can change it, the story, and get away with it, etc. I said that was a question for his copyright attorney. Offhand, I asked where he was, when, and if he knew what the bartender looked like. He gave me all that. He was going to ask his copyright lawyer, as he has a good start on the idea. Few days later, I was able to track down the guy working the bar at the place he was at. Guy calls me back, explain who I am, and ask him if he by any chance remembers the scenario I laid out. He starts laughing. He finally responds, "Yeah, I remember those two. They were blitzed out of their minds. They were doing bumps at my bar, and that's why I came over. Then they wrote up that shoot and asked me to sign it. I did, but we had to ask them to get the fudge out when the guy pulled out a pipe. I asked if he happened to know what happened to the paper they signed. He said, I threw that shoot away. It was all gibberish and illegible anyway. I just pretended to sign it with a straw because it was the only way they leave. But hey, I will say your guy left me a 75 tip. I hung up and texted my client back that I had taken care of it, and his response was praying hands and 3K cover your time. Dude got an option with his idea he and his bar buddy cooked up, but never got produced. Story 14. Not dumb, but definitely not anticipated. I was representing a kid who was about to turn 18 and lose his Social Security benefits because while he met the requirements as a minor, he did not meet the cognitive requirements as an adult. He was too smart. Our argument was that while his cognitive tests showed he had progressed, he was still unable to hold down any sort of employment due to diagnosed PTSD stemming from persistent harassment at school and a violent incident where he had been mugged on school property. I had reviewed our argument and had planned on his mother providing significant testimony. We had gone through the traumatic scenario a few times and he was able to describe it without problem. Because of this, I was comfortable having him testify on his own behalf in court. However, when it came time for him to recount the scenario in court before the administrative law judge, he totally broke down. He was basically inconsolable and utterly incomprehensible. We never ended up getting to his mother's testimony. I thought I had tanked his case and felt horrible for putting him in that situation. They ended up prevailing, though, largely because he demonstrated that upon even being reminded of that situation, he was not able to maintain any sort of composure and needed such support that his prospects of finding and maintaining employment were zero. Answer: I have done that. I have cerebral palsy. I have a low-paying retail job because that is all I can do. I was an adult destitute child, and my father was required to pay support past 18. My father was a narcissist who sued to end support because I could do a job, not if I could support, have a house, and more. My mom was served with papers on Mother's Day morning. I was ready to testify. I am smart enough, but learning issues and more put me in a position to fail if appropriate support is not provided. But I had to recount multiple times where I had failed because it was just my limitations. My learning issues and more that set me to fail. Recounted it enough that I just broke down and cried. No one ever wants to have reality crush that hard. Also, that someone has no empathy. My mom won the case, and I still got support from my father. I never saw or spoke to him again. You know why. Story 15. Lady worked for a missile factory making missiles for the Air Force, had a bogus bodily injury claim off a fender bender, was treating with some questionable medical practices that get paid out of the proceeds of the lawsuit, so we were already suspicious. Come to find out, her treatment records show her being treated when she is logged into the Secure Access Missile Facility, monitored by the U.S. government contractor. On cross, I showed her both sets of records and asked her to pick which ones were more likely to be true, the missile factory with the secure facility or the medical practice trying to get paid out of her lawsuit. She picked missile factory. She wound up losing and owing my client $230,000 in legal fees, which her plaintiff's law firm had to partially cover. They don't put that possibility on the billboards, y'all. Story 16. I was involved in an entirely normal paternity case where a woman had a baby and filed for paternity. The guy disputed it and said he wasn't the father as usual, and the court ordered the standard paternity test. The test results said he wasn't the father of the baby, but surprisingly, it also excluded the mother. After a lot of discussion, we kind of heard off the record that the mother probably borrowed someone else's baby in order to make a child support claim and didn't understand that when a court orders a DNA test, they usually test the mother against the baby as well. Story 17. Client facing a termination of parental rights case calls me the day of the trial to tell me she can't make it to court because her current boyfriend surprised her with tickets to the Caribbean. Actually told me to call her after the trial to let her know how it went. Spoiler alert, it did not go well. Story 18. Interning for a public defender. Statutory violation case. 30-year-old defendant accused of having intimacy with a teenager. Gross, but everyone's entitled to a fair trial. Paralegal gave me a recording of a phone call from the jail where the defendant was being held. Asked me to transcribe it. Apparently the prosecution has just entered it into evidence. I listened to the phone call. It's the defendant calling the teenager he'd been accused of having intimacy with from jail to tell her how much he couldn't wait to have intimacy with her once he got out of jail. He explicitly admitted to the accusations and made it clear it hadn't been a one-off, but rather a repeat occurrence, something that had, up to that point, been in contention, turned into a quick plea deal. Answer: don't be shocked if you stick in criminal work that this is common. I had a domestic violence case where we were going to the last call before trial, and I had just gotten jailhouse tapes the night before. I didn't have time to go through the multiple hours before the hearing, so had to rely on a quick skim, but it was clearly going to be 2 CDs, maybe 3 worth. I tell the court this, and the defense immediately tries to jump down my throat, withholding evidence and such. But the judge and I were both cool, so I asked the PD which one they'd prefer to be the first exhibit. The CD titled, "Babe, Babe, I love you, babe, please, I love you," or the one starting mocking crying noises. "Please, it is so hard in here." I mean, I'm fine either way. I haven't heard the entire thing, but probation, can you confirm that the defendant has a no-contact order with the probation nodding victim? Story 19. It was a class action data breach case. We were suing a company who had accidentally emailed out thousands of their customers' info to a group of scammers. Ridiculous negligence. Complete disregard of even the most bare-bones data protection scheme. Bunch of arrogant, rich assholes. Now, due to some procedural weirdness, we had to prove that our class representative specifically had monetary damages as a result of the data breach, which would normally be a huge problem because actual provable damages as a result of a data breach are extremely rare. But we had a class representative who was pretty unusual. He had gotten the boilerplate notice of data breach and had absolutely freaked out about it. Panic attacks, medical problems, lost his job. So in a 1 in a million situation, we had an opportunity to actually hold these people accountable for damaging the whole class of tens of thousands of people. The defendants got our representative's employee file in discovery and found he had been fired for a 3rd strike of missing work. He had been home with a panic attack, but they wanted to show that he had skipped work for his daughter's school field trip, which had actually been his 2nd strike. So we showed up to a hearing with an elementary school field trip schedule, which allowed us to recover millions of dollars for the class. Story 20. I don't have a really great one of my own yet, so I'll share one of my bosses. We repped an event company that was putting on a hot air balloon show on behalf of a city that had gotten out of the case on sovereign immunity grounds. The plaintiff was a volunteer who had signed up through the city's program, so hadn't signed a waiver with our company and wasn't supposed to be helping with the hot air balloon stuff at all. The volunteers were supposed to be doing things like setting up booths and putting out chairs. Anyway, plaintiff came over to the balloon area, asked if they needed any help, and was told sure, he can help hold one of the ropes while the balloon is being raised. Something to do with it needing to be loose while being raised, and then they could tie it down after. Not entirely sure of the specifics on that. It wasn't a main issue. Plaintiff was told to put on some gloves, but he didn't, and to absolutely not wrap the rope around his hand. He did. Surprise, surprise, the balloon jerked and ripped the skin off part of his hand. Ultimately, he only had about $6,000 in medical bills because it wasn't that serious. Didn't lose a finger or tear a tendon or anything, just the skin. Now, 95 of personal injury cases in my jurisdiction are valued essentially by just taking the meds and doing a multiplier of like 1.5 to 3 for pain and suffering, with practically all of them settling in that kind of range. Given the nature of the injury, though, we were on the higher end. So the value range we had on it was 3 Termavvex or $18,000, $30,000. Now that's an expected jury verdict range. So settlement offers tend to be lower earlier on since they'd save time and expenses against actually taking it to trial. We offered $12,000 before trial, got rejected. They were at $250,000 still. Probably could have gotten our client up to $20,000 or so if they'd actually tried negotiating, but they didn't. Anyway, at trial, they're playing it up as the worst injury imaginable and that he's traumatized for life and can't deal with his ugly scarred hand. After quite a long back and forth between plaintiff and his attorney, as plaintiff describes how disfigured the hand is and how he wears a glove all the time now so people don't have to see it, plaintiff's counsel kind of does a dramatic pause, turns toward the jury and goes, "Well, show it to him." So plaintiff takes off the glove, sticks out his hand toward the jury, and the whole jury leans in, squints, looks at plaintiff's counsel, back to the hand, and then kind of lean back with all sorts of looks of confusion on their faces because there was barely even a scar. Verdict was the medical bills only down to the penny. The thing is, the initial photos were pretty gruesome, as you'd expect when a person is missing skin from half their hand with blood everywhere. Those were in evidence, and the jury definitely reacted to them at the time. But by playing up the long-term, lifelong emotional distress from the totally permanently disfigured hand, he basically lost all sympathy. If it had been me, I'd have had him admit that everything's okay now and he's grateful for that, but he deserves to be compensated for having to go through the ordeal and the obviously immense pain he felt during the recovery. But, oh well. Story 21. I was on a jury once for a road rage incident. The guy was driving a truck and forced a young girl in a car to hit a barrier wall. The defense attorney tried to paint the girl as an addict and was very belittling to her on the stand. It made us sympathetic to her, not the other way around. There were also witnesses that all basically said the same thing. The guy was at fault. The only thing we didn't find him guilty of was the damage to the vehicle because the prosecutor never brought or showed proof of the damages to the car, just that it was totaled. Story 22. Not a lawyer, but one of my employees' stories. He went out on disability for a sore back. Happened a lot in the union. Come springtime, guys would say they're going to visit Dr. Summeroff. He was also an urchin diver, and when the company sent someone around to make sure the guy wasn't scamming the system, they took photos and videos of him going in and coming out of the water in full scuba gear. Took the guy to court, and his defense was that they couldn't prove it wasn't his twin brother. Case dismissed. Guy came back to work in the fall. Answer. There was a famous burglary in a department store in Berlin in 2009, where jewelry and watches valued $2 million were stolen. Police found DNA traces that were already on file for well-known criminals, which could therefore be quickly apprehended. Problem. There was only a single trace in a glove, matching the DNA of twin brothers. Since there was no other evidence, they ultimately could not be convicted because it was impossible to say which of the two brothers left the trace. They had to let them go. Most of the stolen valuables never resurfaced. State attorney tried again 10 years later with more modern technology, but again they had to give up. Story 23. Not an attorney, was a pre-law student before switching to engineering my junior year. Now I have master in planning and a MLS in land use and environmental law, so I'm familiar, but was sued for getting rear-ended. Yeah, you read that correctly. I braked suddenly to avoid a deer, and a guy rear-ended me. The guy had recently had a spinal fusion in his neck, and his airbag messed up the hardware, so he figured it was his shot for a payday. As soon as the responding officer showed up and the guy who hit me flashed his badge, I knew I was not going to get fair treatment. I didn't. The responding officer did not write him a single ticket, but wrote me a ticket for reckless driving and coming to a sudden stop without adequate signal. My insurance company offered to settle with him for $20K, but he wasn't having it. So off to a deposition I went. The deposition went well, I thought, and my insurance company made another offer of $60K. Again, his ambulance chaser lawyer, plastered on billboards all over, said no and said their offer was $500K. Story 25. Guessing random numbers between 1 and 10. People will always lean towards choosing 3 or 7. Even numbers are too organized, not random enough. So we don't pick those. Not going to pick 1, 5, or 10 because they're at the ends middle, and so we also don't think those as random. For some reason, we also don't pick 9 either, presumably again because it's too close to the end of the list. Answer. Also, some number tricks can make things seem like magic. Fact, any number divisible by 9, the sum of its digits are divisible by 9. If you repeat until you have a single digit, you get 9, 81, 81, 9, or 34, 9, 7, 3, 4, 9, 7, 27, and then 27, 9. You can use this fact to start manipulating a known value and get the other person to arrive at something you know beforehand. So for example, pick a number from 1 to whatever. I'll do 1 to 20 to make mental math easier. Divide it by 2 and round to the nearest number. I do this to make mental math even easier. Add 5. Don't care what they have. Multiply by 3. Multiply by 3 again. They've now multiplied by 9. Add all the digits up. You now know they have 9. Subtract 7. They have 2. Multiply by 3. They have 6. Pick the letter of the alphabet that matches that number. F is the 6th letter. Think of a U.S. state that begins with that letter. Florida is the only state that begins with F. You're thinking of Florida. You can also lead them towards Delaware, Utah, Louisiana, Pennsylvania, Hawaii, Georgia, or Rhode Island. I use Florida because it seems like it's easiest to come up with, but sometimes I'll use Delaware. I used to use animals and get people to land on E and pick elephant, until some kid who likes Sonic said echidna, and I was like, what the fudge is an echidna? But there were also eels, eagles, too much variation. But people did tend to pick elephant. Story 26. Palm reading. Here's the trick. Just make it the fudge up. Nobody will ever know or question you about it. Answer. Still feel guilty that when I overheard a colleague say she would like to get her palm read, I turned to her and said, I know how, and then bullshitted until I went. And this line says you're really gullible, and she didn't get it. And I felt like a monster because I had to explain that I was making fun of her. She's a smart person, but that face of eagerness to hear more and blind trust, I will never forget it. Story 27. The best way to make people think you are super smart when you are not is learning to solve a Rubik's Cube. It took me about 2 hours to learn how to solve when I was 13 from a YouTube video. The best way to then humble yourself is to go to a Rubik's Cube competition and watch 9-year-old kids solve it in 6 seconds and wonder what you are doing with your life. Story 28. Everyone should learn to draw, even a little bit. No, you're not going to become amazing at it overnight. And no, you're probably not going to make a bunch of money as a famous artist. That's not the point. The point is, drawing teaches you to observe, and it gives you a tool to record what you're observing. Yes, I know you have a camera phone. That's not the point. Drawing is the process of getting you to stop, look, listen, and record what you are seeing. Story 29. When I was a child, I thought that using washing machine is way too hard, The same with dishwasher or how to clean glass. Story 30. Latte art. Takes some practice, but as long as you get the milk down and move quickly, it's pretty easy. Even the complex designs aren't that hard. Making it taste good is harder, but the art, I could train anyone to have it down in a week. Story 31. Drawing. The trick is learning to see. Translating visual information is the entire ballgame. A great way to learn this is to try to reproduce a picture of the model subject on a magazine cover. Turn the image upside down before beginning. It forces your brain to see shapes and their relationships to each other, and not just the symbols we create in our minds for things like nose, eyes, mouth, etc. Answer. Apparently my brain has just got stuck on reproducing pictures because my drawing's pretty decent. When I have a direct reference to draw, I've drawn highly detailed manga characters pretty easily like that. But take that reference away and tell me to draw that same exact character again. If I do it 5 minutes after copying, maybe it'll still look halfway decent. Ask me a day or two later, the drawing will look like shoot. Story 32. Research. People act like it's one of the most difficult things to do. It isn't. If you're curious enough about something, you can spend hours, days, weeks, and months, even years learning about things. Story 33. Baking. Baking is science. Just follow the instructions. Cooking is art. Season to taste and experiment. Answer. Yes. Baking is much easier for me personally because it is so precise. Use a digital scale and measure everything precisely, and it will turn out correctly 100 of the time. The art of cooking is something I've found much more elusive. My partner is much better at that and has done a lot to help me. I like to think I've helped them become a better baker as well. Story 34. Painting. There's a reason Bob Ross had a show. Painting is so easy and everybody can do it. Literally just put paint to paper canvas. Paint whatever you like. Paint words, paint rocks, paint abstract colors and splatters. Paint your dog. Don't think you can paint your dog. Pick a color, slap a shape onto the canvas. That's your dog now. Art can look like anything. Just paint, please. Story 35. Guitar. I thought it would be really hard at first, but after getting a few open chords to ring out correctly, everything started getting easier. The trick is to forget that your fingers hurt like hell. Story 36. I don't know if it's a skill, but my clothes dryer drum quit working one day. My wife was stressed, looking at buying a new one and taking a 500 hit on our monthly budget. It took me about an hour taking it apart. The belt fell off the motor. I put the belt back on, put it back together, and it worked perfectly. 2 out of 12 hours of having no clue what I was doing, but taking pictures of every step so I could go in reverse. I learned that trick from iFixit. So repairing appliances is now one of my skills. Story 37. Piano arpeggios. Okay, bear with me. You know how you can count by ones, right? 1, 2, 3, 4, and so on. But you don't have to be a genius to count by twos either. 2, 4, 6, 8, and so on. And you can probably count by fives, and maybe by threes if you take your time. Once you know the pattern, you can count upward by that pattern forever. A basic arpeggio on the piano is just repeating a pattern up or down the keyboard. It's not as simple as counting by twos, but there is absolutely a pattern, and it's a simple pattern. And if you can just apply the pattern, you can practice the basic pattern, you can add tiny flourishes and end up with a Liberace arpeggio, which looks super impressive, but it's really just a simple pattern repeated quickly. Story 38. Math. All you have to do is follow the exact steps in order. It's spelled out for you. The problem comes in the way we use it to torture children. We cram as much of it into a child as fast as possible, with not even enough time to remember what the procedures are, and with no regard to different learning styles and rates. If you are ever able to work past the trauma that we as a society absolutely induce on our children, and take up learning math on your own, at your own pace, it's actually fun. Like a bunch of little, simple puzzles. Puzzles, not problems. Why do we call them math problems? Nobody wants to deal with a problem. Everybody loves puzzles that build on each other as you advance in levels. It's like doing a Wordle or a Sudoku or a word search. I think a big part of why we have so many deliberate anti-intellectuals that vote like morons is because we tortured them with education when they were children. We need to stop doing that, which means that parents first need to let go of the way they learn things and accept that we need to do things differently. Story 39. Drawing. Your first drawing will be terrible. Your 10,000th drawing will be good. That's basically guaranteed. When people say they wish they had drawing talent, what they are saying is that they wish their 10th drawing was as good as someone else's 10,000th drawing. If you want to be good at drawing, all you have to do is draw a lot. Edit. Some of y'all are missing the point. 10,000 hours of practice isn't going to make me an Olympic-level gymnast. Some of y'all can never be good opera singers because you don't have the talent. Anyone can draw, I promise. Story 40, playing the Highland bagpipe. It seems complex and mysterious, but really it's just 9 notes, no octaves of scales. It just uses a single scale based on Mixolydian. The more challenging part is the blowing and breathing technique. But with a proper teacher, any motivated person can learn good technique and a bunch of tunes within a good solid year of daily practice. And you have a good practice space where people don't mind the noise. Story 41, making pizza. With a $300 propane pizza oven and watching some YouTube videos, I learned how to make restaurant quality or better pizza in less than a week. Story 42, Indian cooking. People try to drown everything in 30 levels of spices to make it taste like an Indian restaurant, where the cooks are themselves using store-bought spices. You need a basic masala box and ghee. That's all. Begin with vegetarian dishes. Try the simplest dishes, aloo jeera, only tempering with turmeric, cumin, and red chili required. Buy spices whole and powder them at home. Season as you go. Indian food gets a bad rep because folks try to overcomplicate it. Story 43. Basic sleight of hand card tricks. They look like wizardry, but with a few YouTube tutorials you can impress a whole room. Story 44. Doing brakes on cars. You need the correct tools, of course, but the job is relatively straightforward. I think most people's hesitation is that it's such vital safety component, which it is, that they assume it must be complicated and difficult to service. But it's one of the easiest to do yourself. There's quite a bit of vehicle maintenance that's easy to do at home, but brakes seem to be the most impressive to anyone I've done them for. Story 45. Not being a complete fudge jerk, a lot of people seem to think it's impossible, but it's actually super easy. Story 46. Fire poi. Once you get a few moves sorted, the fact you are on fire makes everything look 500 times more amazing. Story 47. Butterfly stroke. It's not hard to do, it's just hard to get it to click. But once it does, you've got it. Now, to do it quickly or for a long time, that takes practice. Story 48. Can't post a picture, but post above this one says, 50 of men aged 25 have never asked a woman out. And I find that incredibly fitting and hilarious. Story 49. Most magic tricks. I don't like to just watch TV, so I try to do something simple while I'm sitting there, like sketching. Years ago, I started learning some false shuffles and simple card tricks that I can do over and over while watching TV, and I've gotten pretty good at it. Many magic tricks that appear to defy reality are done so simply it's frustrating to learn the secret. Story 50. Ordering a custom printed circuit board from a PCB manufacturer. I won't claim that designing PCBs is easy, but basically anyone with a computer, a basic understanding of electricity, and a lot of time on their hands should be able to figure out how to use KiCad to design a basic circuit that works. Once you get over that hurdle, ordering them is easy and surprisingly cheap. There are some additional steps if you want the manufacturer to assemble all the surface mount parts, but those aren't terribly hard either. So far, I've just used JLC PCB. Story 51. Cooking for sure. There are obviously levels to it, but especially if you are just following recipes, it's super cheapasy. Story 52. Whistling really loud with your fingers. Once you get it, you basically unlock the power to stop traffic and summon your friends like a Pokemon. Story 53. Juggling 3 balls. Basic surfing. Yes, surfing can be difficult, but with a long board with the right water conditions of steady small waves, it is relatively easy to stand up and catch a few waves. An average swimmer can begin catching waves within an hour or two of lessons at Waikiki Beach. Answer. My faux uncle is Tongan, a big guy. When I was super little, he told me how his brothers would surf all the time. I, being little unfiltered, asked, "How do you surf on a little board when you're so big, uncle?" He laughed a deep belly laugh that sounds like a little girl laughing. It's his most distinctive quirk. Said, "Oh, child, if the board is long enough, anybody can surf. Even me. My board is very long, but I ride the waves like a dolphin. That gives me confidence that I, no matter my age, will learn to surf when I get the opportunity." Side note, I miss him every day. He developed dementia lives with his family now. He used to pick me up from Taekwondo, invite us to his family's weddings parties. Before the dementia, he was a retired lawyer who spent his free time in soup kitchens. A good man. Story 54. Not a useful skill, more a party trick, but being able to know the exact day any date falls on. It's a pretty simple math trick that most people can learn in an hour. It's called the doomsday algorithm, Numberphile has a good tutorial video on it. Story 55. Knitting and crochet, you can make wild things and now learn it all online. Taught myself to knit with a YouTube video, and now I'm learning crochet the same way. Story 56. You're getting responses from people that are good at something, so it's easy for them. Brain surgery is easy for you if you're a good brain surgeon. Story 57. Miss Excel. Practice a few things and you can amaze some people. I find it hilarious how people will gush over a spreadsheet that took me 10 minutes to create. I have to wait a couple hours before sending, so they think I worked hard on it. Story 58. I've read a lot of replies here. Like 20 jugglings and 50 listings. I just want to say, doing OP's mom. Story 59. Cooking. You can practice every day. The better you get, the more money you save, the happier you are and healthier you'll be. All it takes is trying one new recipe a week, or one tweak a day, or tasting one new food a month. Take it at a deliberate but steady pace, and you will naturally improve your skills. Story 60. Flying a single-engine airplane from takeoff to landing, reasonably safely and within certain parameters. The hardest part is paying for it. Story 61. Juggling. It looks super impressive and intimidating, but once you get the basic rhythm with 2 balls, adding a third becomes surprisingly easy with a bit of practice. Story 62. Probably late to the party, but a lot of simple skate tricks are doable if you just have no fear and are decent at falling. Things like a cigarette or wraparound, facky big spin, shove it, pressure flip, truck stand, etc. can be learned pretty quickly, as long as you have a baseline amount of control over your body. Story 63. Learning a second language. This is sort of specific to the UK and US, where second language rates are abysmal. I can speak German, but have also learned a little Korean and Chinese. It's not that hard. You just have to get started and stick with it. It really is not hard to learn a second language. Answer. I've been learning Spanish as a second language for 2 years. I'm probably an A2 or low B1 right now, and have been putting in 30-90 minutes of daily work. Multiple modalities. Weekly tutoring with a native speaker, daily Duolingo, Closemaster, various podcasts. With a lot of concentration and effort, I can make myself mostly understood and string together basic sentences with mistakes using present, imperative, past, and periphrastic future tenses. I haven't even gotten to subjunctive or any other tenses yet, and still struggle with some of the tenses I've already learned. I usually understand about 50-75 of what people say at a normal speaking rate. My reading comprehension is probably closer to 80 or 90 depending on the topic. My vocabulary is great, I'm just not great at using it. I wouldn't really say any of that as easy. I stick with it because I enjoy it and have already invested too much into learning Spanish to give up now, LOL. That said, I'm guessing some people may naturally pick up on multiple languages more easily than others. Story 64. Kip up. It's where you go from a supine lying position to a standing position by bending at the waist, then kicking your legs out and pushing back with your hands. Learned it when into breakdancing in the 80s. That said, I failed last time I tried it a year ago. Pushing 50. Story 65. Cooking. Besides the principles of food safety, there aren't any rules. Yeah, there's some basic chemistry that makes things easier if you understand it. But beyond that, just make stuff. It's a skill worth knowing and exploring and getting caught up in tradition and flavor principles and whatnot. It's all just made up, so just make your stuff up. Please buy a meat thermometer, cook your meats to temp, and avoid cross-contamination. And don't fudge with canning if you can't follow the rules. Story 66. With your right leg, make a counterclockwise motion, while with your right hand, write the number 6 in the air. Story 67. Making risotto. You need to watch it like a baby, but just pop on a podcast and you're golden. Once you've made one, you know how to make all of them. Story 68. Learning the basic skill set of a wine sommelier. You don't need to have a super impressive palate or natural talent for tasting. It's a learned skill that doesn't take long with the typical grape varietals. Yes, it does take exceptional tasting ability and lots of time to master if you want to be diving into blind tasting down to the vintage and more obscure varietals wine regions. But the basic, this is Cab from Napa, or this is Left Bank Bordeaux, is a surprisingly attainable skill. In terms of the descriptive language used for tasting and smell notes, once your mind shifts from the language being some nebulous, ephemeral thing to it being just another form technical language, giving consistent tasting notes becomes second nature. Just don't use douchey, abstract language that no one understands. For example, if I'm talking to a North American audience, I won't tell them things taste like black currants on the palate because black currants are not really widespread in North America. Developing this skill set helps unlock your sense of taste and smell in a way most people never bother. It increases your enjoyment of food and wine. Because you will know the basics of wine and food pairing, you will be able to somm your own dinners and restaurant outings that don't necessarily have sums. You will also become a better cook because you will be thinking about what you are tasting and smelling in a more systematic way. Learning about wine means you will also learn a lot about history, seeing as wine has been there with us since recorded history began 9,000 years ago. And as long as you don't fall into, look at me and how fancy I fudge am condescension, you will literally bring out the most in parties. Story 69. Solving math problems quickly in your head. In my profession, I work with many so-called math experts who can perform simple multiplication before anybody else can. I've learned over time that these experts just know little tricks to get there. For example, multiplying by 9 comes up often. The trick is to multiply the number by 10 and then subtract the number once. X9, X10. One of my coworkers can see a 4-digit number and immediately tell you a multiplication problem that equates to the number. I still don't know how he does it, but I know there's a trick. Story 70. Basic electronics repair. People are extremely impressed when you replace the obviously blown capacitor in their impossible to find a replacement TV remote or other doodad and get it working as good as new. So much. Often very expensive chute gets tossed that can be fixed with 10 minutes of effort and 30 cents of parts. Story 71. Basic hand sewing, cooking, cocktail making. Make someone a cute little holiday ornament, a stack of 3-ingredient yogurt flatbreads, or a French 75. Fast, easy, few tools or ingredients are needed, and only a little bit of your time. PPL act like it's magic. It's not. It's the wanting to and the practice. Story 72. Backflip on a BMX bike. Not actually that difficult to physically do, but fucking scary to commit to that first real attempt. Story 73. Playing the piano by memory. It's actually far easier than what most people may think. It just requires practice. Is like getting good at a video game. The hard part of playing piano is actually knowing how to read sheet. Story 74. Looking busy. It always amazes me how many people are more concerned with how busy you look instead of the actual output of work. I have spent many years honing the art of looking.